Mhm. Thank you. Good morning. Let's try this again. The time being just after 10 on June 28th, I'm calling to order the Judiciary Subcommittee on House Bills 314 and Senate Bill 255. Although we have two bills that will be before this committee, um, the relationship between the two bills isn't completely parallel, and so I think we should pursue one bill at a time unless anyone has any other feeling. And taking the House bill first, um, I would suggest that we begin with House Bill 314, relative to the expectation of privacy in the collection and use of personal information. The reason this bill is in the subcommittee is that the members of the committee felt that it was very important. It was addressing a timely issue, but as important as it is, that is how complex the issue is, and that we needed more time to be able to delve into what was necessary for us and helpful for us to do now, and what really isn't appropriate for us, a state as against the national government. Um, when we last looked at the bill, of course, we had a lot of testimony, and we also had at least one amendment. Uh, but we're today just going to try to get a sense of where we want to go. We would be meeting today, and then we will not be meeting again until September, following House rules. Uh, but that does mean that if we identify areas where we want to delve deeper, that gives us time for the members of the committee and for the members of the public who are interested to help gather additional information. So that I think is all that I need to say to open the discussion. Chairman Lynn, do you have anything you want to add?
No, I mean, well, I do have just a couple of things, and I guess what I would say is, I agree with you, your initial remark that the overlap, the relationship between 255 and 314 it certainly doesn't sort of neatly fit together. I agree with that, but what I had been hoping that we might do, and I'm not really, it's not clear to me that it's possible to do this, but I wonder if it would be worth seeing if, because 255 is deals with the privacy issue with regard to private businesses, basically, and 314, um, particularly if we amended it in a way that said 314 applies to private businesses only insofar as 255. In other words, it referenced 255 by in 314 to say that 314 applies to private businesses only insofar as it as 255 covers private businesses, and then the other part of 314, we're dealing with governmental entities. That would be an expansion of 255, which would apply only to governmental entities. And for example, one of the big differences there would be that 314 does create a private right of action against the government. And so I don't know whether it would be possible to do that or not. And one of the things that I think I would think would be very helpful in that regard is, it's clear that the people who brought us 255 spent, I mean, the you know, sort of the experts from around the country spent a lot of time on it, and did, you know, it did a very good job in my view of their drafting. And I'm wondering if we might be able to engage some of those people to take a look at 314 and see if that melding of 314 in the way I described could be done in a in an effective way. Because one of the problems that I see with 314 now is the way it's worded. It says in section 507 H2 Roman numeral 2, no governmental entity shall acquire, collect, retain, or use any personal information of any individual residing in New Hampshire.
Where are you in that?
Oh, I'm sorry. It's on page 1 of the bill, and I'm on line 24. It says no government entity shall acquire, collect, retain, or use any personal information of any individual residing in New Hampshire from any third-party provider. And so that's sort of a blanket statement. It would be, I mean, if you ended your consideration right there, you'd basically say no government entity can ever have any private information acquired from a third party, which would be really, I mean, that would be kind of crazy. But then if you go on to section 3, you see that there's a huge number of exceptions. So effectively, the way it's drafted, subsection 2 kind of says, thou shalt not, except in the areas covered by subsection 3, which is huge. I mean, just for example, read 3A. It says subparagraph 2, the broad prohibition doesn't apply to personal information acquired, collected, retained, or used by any state regulatory or administrative agency when such acquisition, collection, retention, or use is within the agency's regulatory, investigative, adjudicatory, or administrative function. Well, on its face, that would seem to, I mean, you know, except for situations where a regulatory agency or some agency of government was acting in bad faith, except for that, you'd almost think that almost everything would be accepted, because if an agency collects information that they have some reasonable basis that they think is necessary to do their job, presumably that would fall within that exception. So it's unlike 255. I think 314 may be drafted in a way that is just it oversimplifies, and that may mean that it would take a considerable amount of work to make it fit in. And that's why I was kind of wondering if some of the people who have had some expertise in this area might be willing to take a stab at trying to make it fit in.
Thank you. Let me ask you a question. The Department of Motor Vehicles, for example, collects the information necessary to issue driver's licenses. What if the Department of Motor Vehicles, honoring the fact that we live in a capitalist system, decide that they want to sell all that information to private users? Without regard to existing law, isn't that an example of, or is that an example of how a regulatory agency might, you know, thinking for the best of reasons, utilize this information in a way that really isn't central to their regulatory, investigative, adjudicatory, or administrative function? And there are other examples. I mean, I just
Sure. No, I agree with you. I think that's
and
right.
so, and I think we do see that. We see that with the 9/11 system, where the information is collected for a very specific reason, but there, other agencies want to get a crack at that information also. And the basic problem, I think, is is real. It's not imaginary or, um, or just creative thinking.
Yeah, no, I know, I agree with you. Oh, I agree, and I think that's why I think 314 really is important. It's just I would like it if, I mean, it would seem to me it would make sense if we could do it to have a sort of comprehensive privacy um, bill that applied both to private enterprise and to
And
the government.
and to the government. I hear that now. And just at the introductory level, anybody else on the committee have something to say? Representative Alexander?
Thank you, Madam Chair. I remember we were on a subcommittee about this bill last term. The
You
one
have a very long memory.
very long memory. So the thing I like about 314 is it concerns government entity, and I think if we're gonna start with regulating, it should start with ourselves, in my opinion. And then what I like about 255 is that it is like more it's very specific and very like there's strong definitions. So I don't know how we can work that through to make it so maybe if we start with government entity and then see if it works and then expand it to non-government entities, if that works. I mean, why can't we just have a law that says you can't share personal information and that's it, right? Like, I don't, do we have to go wicked specific, or can we kind of just stay
Well,
broad?
one of the problems, Representative Alexander, is that if you make it too simple, then what would the legislature do to keep itself busy? Representative Tour?
Yeah, thanks. Um, just looking at 314, I think it's interesting that the clause above the one that Representative Lynn just pointed out, the first thing that it states is really broad, and it just says individuals shall have a reasonable expectation of privacy and personal information, including content and usage given or available to any third party providers of information and services not available to the public. So that's on line 21. So it starts off with this very broad statement about what 314 is doing, and then it's not really until all the way toward the bottom of the bill on line 26 that it says action against a non-government entity shall not be construed.
Where do you see that?
Oh, on
yes,
line
page,
26. Sorry,
Page two, line 26, 507
So
H colon 3.
Yeah. So it doesn't really seem. I know we've thought about this as a government-only bill, but it seems to only basically carve itself out as a government-only bill down at the very bottom. And so I don't know if that sort of lends itself to merging in with the other concept, because the other concept taking care of all those other entities. Essentially, one's leaving one out, this one's leaving the other group out. And just the way this is put together seems really confusing, because it starts out not really specifically talking about government entities. Then it starts carving out a whole bunch of exceptions, and then only at the very end does it basically clarify that it doesn't create an action against a government entity. So I don't know if there's any knowledge about why it's structured that way, or if it has to be.
Well, you know, I'm sorry.
No, no.
May I just?
Oh, sure, of course.
If I may. You know, I was going to say, you raised that's an excellent point, and that is a point. That was what I attempted to deal with in the amendment that I had, and you'll see that what my proposed amendment to
314.
to
To 314, Amendment
Yes,
0194.
yes, right, and what that was attempted to do is to amend 507H2 Roman numeral 1 that starts on line 21, so that it would say the reasonable expectation of privacy applies to information given or available to a third party. I'm sorry. I better read. An individual should have a reasonable expectation of privacy and personal information, including content and usage, given or available to third-party providers of information and services. I I took out the word and, so providers of third-party of information and services, comma, not available to the public, comma, and then the important thing is I added the words and provided to a governmental entity, so that, and I know I had a long discussion with Representative Erf about this. I think he disagreed with that limitation, but my purpose in having that limitation was to say, to make that this section sort of congruous with the cause of action section, so that it was the expectation of privacy was only when the information that's in private hands gets into the hands of the government, then it becomes private. And I guess what I would say is, if we were gonna, combine 255 and 314 in some fashion, that Roman numeral 1 of section H2, where it says except as otherwise provided in law, I mean, if we adopted 255, that could be the other law that would apply, to the private sector information.
Thank you.
No problem.
Does anyone else on the committee have any introductory comments that they want to make? Seeing the representative, the prime sponsors of 314 are Representative Erf and Representative Lynn. Representative Erf is here, and if I'm not incorrect, he's here also with a colleague from his district who's a former representative, and that's former Chairman Neil Kirk. And if it's all right with the committee, I would suggest that the Messieurs Erf and Kirk come up and help us start our conversation here about 314, including how it may or may not relate to 255. Are you willing to do that, Keith?
I am, and that's fair, but
Good. Well, when you build a building with lots of different pieces, first you have to figure out, well, you have to figure out two things: what you want to build and what the pieces are that you have available to build with. And that's our, it's like Robert Frost, when you build a wall, you have to figure out what you're walling in and walling out. Representative Kirk, Chairman Kirk, Mr. Kirk.
Thank you, Madam Chairman. Neil Kirk from Ware. I'm very pleased to be here, and I appreciate the opportunity to speak to you. There is a connection between the two bills, but it's tenuous. 255 deals with large private companies which collect information about individuals through a variety of ways, and provides opportunities for individuals to opt out of the company using that information for a variety of purposes. As written, 314 deals only with information that comes from third-party providers. It's a very limited subset of the information that's out in the world. So the only information that is covered by 314 is information in the hands of a telephone company or social service media or a financial institution or something like that, where there is a business relationship between the individual and that company. So the individual decides he wants telephone service, provides information to Verizon. Verizon is now a third-party provider of information and services, not goods. Goods is covered by 255, but not 314. And then the question is, to what extent can Verizon use that information for other purposes, other than to provide the services for which the individual arranged a relationship. Under U.S. Supreme Court decisions, there are no limitations. That information under their third-party doctrine is the property of Verizon in effect, and they can do what they want with it. You have no expectation of privacy in that information. The purpose of 314 is to change that. It's to say that when an individual gives his information to one of these third-party providers of goods and services, that provider can only use that information to service the individual whose account was established. They do not have the right to use that information for other purposes. Okay? If a state agency wants to get that information, or a private sector individual wants to get that information, they have to go through a process. They can't just get it by asking. Under current law, if the police want information from Verizon about Neil Kirk, they can either call them up directly and say, hi, would you give it to me? Or if that's not the way Verizon operates, they can get a subpoena, which is not based on probable cause, just a subpoena. And then Verizon, while it could fight it, would not, and they would get the information. If this bill were to be passed, the police would have to get a search warrant based on probable cause if they wanted to get that information. And they would have to do it on an individual basis. The police, for example, today could collect wholesale information about everybody in New Hampshire and create a database if they wish to do so. They don't, but if they wish to, they could. If this were to pass, they could not do that except on an individual basis based on probable cause. So the focus of 314 is very different from the focus of 255. There is a connection, as Representative Lynn has pointed out. I'm not sure it's worth merging the two to deal with that connection, but there is a relationship. Representative Lynn's amendment would basically eliminate the part of this bill that deals with individuals, because this bill really has two parts to it. One, the government restriction part, that's H22, line 24. And then the individual part, the private sector part, which is H21, line 21. If you eliminate section 1, and Representative Lynn's amendment effectively did, you kept the language, but by adding the words at the end about a government, you basically eliminated the right of Neil Kirk as an individual to tell Verizon not to give his information to somebody. So that's the effect of your amendment. It would only apply to government. And you're right again, Representative Lynn, the substantial list of exceptions was designed after meeting Representative Erf and I with many government agencies, was designed to say, look, whatever the agency is doing currently, it should be allowed to continue. That's the practice. So this has a significant impact. Representative Smith's example is one, but it would apply to the police, which is why they oppose this, because it would require them to get a warrant, a search warrant, rather than simply a subpoena to get information from these folks, if they wanted to do that. I hope Representative Lynn might rethink his objection to having the private individual have the same protection that is provided in this bill. I think that's very important. But I understand his position, and if that were to be the wish of the committee, it's still worth passing the bill, because what we've done is basically to say we're keeping the situation that currently exists in existence, and if in the future the legislature thinks that the Insurance Department or the Health and Human Services Department should not be able to access these third-party providers to get information about Neil Kirk, then the legislature could make a separate determination in each of those cases. The other thing that's important about this bill, and indeed to some extent about 255, is that it deals with the new constitution, well, not really 255, I shouldn't say that. 314 deals with the new constitutional privacy provision, which is very broad in terms of protecting personal information from government intrusion. So this would be the first legislative statement about its concept of what that amendment means. It's saying that government agencies in certain ways may and certain ways may not access personal information. I'd be willing to work with Representative Lynn or the committee or produce any kinds of amendments that you want if you have a policy position on what you want this bill to accomplish. And it can be made to accomplish many things, but the concern that this bill addresses, to repeat, is information that you voluntarily give to an organization that's providing you information or services. This does not apply to goods. This does not apply to anything you buy in stores. It's just where you, the individual, have a relationship with a provider of goods and services defined in the bill and want to maintain the privacy of that information and not have the provider use that information for its own purposes, to sell it, to make it available to the other private sector organizations, to make it available to government. I think that's a very important privacy protection for the citizens of New Hampshire. When I give information to the telephone company, I don't want them revealing it to Microsoft. None of Microsoft's business, the relationship that I have with the phone company. And I'm very pleased if the police, in order to get that information, would have to get a search warrant. I mean, if they wanted to get that information from my house, they'd have to get a search warrant. Anyway, as you know, I'm passionate about privacy, so you'll deduct whatever points are necessary from my passion to make a reasonable decision. Thank you, Madam Chairman.
Thank you. Representative Burke, do you have anything you want to add at this point?
I think he covered it pretty well.
Thank you. Anyone on the committee have any questions that they would like to ask the witnesses? Representative Turer.
Yeah, just one question. Along the way, you had said that the Supreme Court had eliminated this provision or something along these lines previously. Was that on constitutional grounds, or what was the reason that the Supreme Court found that the existing law, and sorry if I'm not stating that perfectly, couldn't exist?
Representative Lynn is better qualified than I am to answer that question, but basically the U.S. Supreme Court said the Constitution did not protect that under any concept of privacy. That was their interpretation of the U.S. Constitution. And our state Supreme Court, I think, generally has followed that with certain exceptions. For example, there's a very famous case where our Supreme Court said you have a constitutional right to privacy with respect to garbage that you throw out in a black plastic bag on your front lawn, so to speak. When that's picked up and taken to the dump by the garbage people, however it's done, you have not given up your expectation of privacy in that, and the police, if they want to search it, would have to get a warrant. But in New Hampshire, there is no constitutional or legislative privacy protection with respect to third-party provider information that you've given to it. Now, clearly, somebody could bring a legal case and claim that under the new constitutional amendment, that indeed is protected information. The situation hasn't arisen yet, and I would hope that the legislature, in light of the amendment, would adopt this bill and others like it to define what kind of information government has. Remember, the constitutional amendment only applies to government. It doesn't apply to the private sector. It limits government's acquisition of information about its citizens. I would have liked it to apply to the private sector, but that's not the way the amendment went.
Just a quick follow-up.
Yes, of course.
So that Supreme Court decision, if I'm understanding what you're saying, it basically said the right does not exist, the right to privacy over data does not exist in the Constitution, but it didn't prohibit something like this from being added, which would establish it.
That's correct.
Okay.
Any other questions or comments? Thank you very much. What we're doing today is just trying to gather information and have a sense of where we want to go from here, and benefit, of course, from the thinking of people who are following these issues. Is there anyone here in the in the room who would like to comment on, help advise and guide us as to where we should go? Yes. Good morning, Representative.
Good morning. Representative Tim McGee, one of the co-sponsors of the bill. First-
Which, your co?
255.
Yeah, okay.
Sorry I haven't seen you before. It seems that every time that we have one of these hearings, I'm either at a healthcare conference, like the 1 week of the session that I was at and I'm going to tell you a little bit about it. So please indulge me if you don't mind. This is going to be a little bit of testimony that probably would have helped, but we had a lot of esteemed co-sponsors and knowledgeable folks testifying. So some of my original testimony might have been redundant, but as this bill has taken shape, I'll throw in a couple of cents. So my first 2 terms were spent on commerce in 1996 to 2000. And back then, I think one of the things that I ran on was the right to privacy. And as you know, that predated our amendment. And Representative Kirk was chairman of finance, I believe, then, right? And we had a common interest in the right to privacy then, as I do now. And I was entering healthcare as a medical device commercialization guy, and HIPAA was new and nobody knew what it meant. We all thought it would protect our privacy, but everybody ignored the second P in HIPAA. Does everybody here know what that second P stands for? Portability. That means that your data is incredibly portable. So you go to one pharmacy and they know that 5 minutes earlier you were at the last pharmacy. Well, fast forward 22 years, and I was watching the Super Bowl last year during COVID, and I'm kind of a gadget guy. I've developed a few apps. I've got 9 patents in cardiovascular devices. And once I stumped Apple, they wrote back and said, "We don't know what to do with your app. We've never seen anything like it." And it was the best compliment I'd ever had. The Super Bowl commercial had a device on it during COVID called the Q Health device, CUE. And if you're not familiar with it, you should all get one. I have no interest in the company. But it was revolutionary. It was a tiny little box about this big, maybe 3 by 2 inches, and it's a diagnostic device. And I should tell you that I am chief commercial officer for a publicly traded medical device company, a diagnostics device company. Not this one. I wish. So this little device, Q Health, aims to be in everybody's house for every consumer to help diagnose a whole host of ailments. Their first was COVID. And I immediately ordered this subscription device because it was going to provide me with the ability to travel back and forth across the border to my company headquarters in Toronto. And at the time, you needed a certain type of approved COVID test. You couldn't just have the little free government lateral flow test or the one you could buy from the drugstore. You needed the higher level PCR test. So do you remember when there were all the different types, certain were approved for airline travel? Well, this one would allow you to do it in your house with a video proctor. Anyhow, the point of this is there's those big, long EULA agreements, end user licensing agreements, that everybody just scrolls through. Some of them don't even make you scroll through it until the green accept or submit bar shows up. And you've probably had this question in testimony. How many of you actually read those, right? The answer is nobody. At least no consumer reads those. Justice Lynn reads them and then writes back to them and asks for a new copy and sends a red line with track changes, right? Right? He and I are the only ones that ever do that, and then our accounts get canceled. No, just kidding. But if you want to use those apps or those devices, or if you're a business that wants the consumer to buy those devices, and that's the focus I want to bring to this discussion. If you're a business like mine or like Q Health or one of the zillions of other, venture capital funded or private equity funded businesses that's trying to make a go of it, and there's thousands and thousands of these businesses, many of them trying to come to New Hampshire, and I'm actually trying to move my company to New Hampshire here in the midst of a bit of a restructuring. They need this. What's that?
I'm sure the governor would help you.
He just might. He just might. We enjoyed a nice relationship. So if I'm one of those businesses, and when I was asked to co-sponsor this, and I spoke with some of the interested parties like Microsoft, I happily signed on. I said, as long as it's reasonably close to Connecticut and nothing like California. And when I look at this chart and I see how many X's we have on here, I think, well, that's a state that I'd like to do business in, because that's a state where my consumer customers, where it will be easier to be not just a B2B, business to business manufacturer and distributor, but also a business to consumer.
Excuse me, what were you holding up there?
Oh, this is the tracker that shows what states have done what, and
Okay.
which bills contain right to access, right to correct, and right to delete. That's what resonates. Even at the town committee level, if you're giving a legislative update to your local committee, you can tell them, hey, I worked on your right to privacy. They get that. But did you know you don't have the right to delete yourself? And that rings a bell. I mean, how exciting is that to deliver that to your constituents in some fashion? The right to electronically delete yourself. Nobody believes that that's even a possibility. It's number 3 when you turn it sideways. And you go down here, and New Hampshire is maybe the only state, or one of the very few states, where the pending legislation, Senate Bill 255, checks all the boxes. And someone behind me will correct me, but I think we have.
No, the private right of action.
Private right. Yeah. Yes.
And then,
Thanks for bringing that one up.
And then a minus on
X minus on one of them. That's right.
on right against automated decision making, whatever the
AI. Yes. Don't get me started on Chat GPT. If you don't know what it is, you should learn about it. But sure, I think those are two things that maybe are better left for the next session, like Representative Kirk mentioned. Happy to give you my opinion on it. I think you probably had a lot of discussion on private right of action already, and maybe best left for the next one. What you have as Representative Lynn has amended, I think, is a pretty good step, and it's personally widely supported. In terms of full disclosure, our particular business would not directly benefit from passage of this one way or the other. We do not have a consumer product in the mix or planned to be in the mix anytime in the next 2 years. So I have no particular disclosure or no particular conflict with the passage of this legislation, or I probably wouldn't have sponsored it. But from
one would hope.
One would hope. One would hope. But at least from a business perspective, I can tell you from healthcare businesses and people who are trying to bring products into the market and make it easy for payers and providers, payers and manufacturers to encourage consumers to utilize their products in their homes and self-diagnose or get healthcare information. All those consumers have to click on those end user licensing agreements, have to agree to allow their healthcare data to be in the cloud somewhere, and they'll do it more readily if they know they have control of the data. We want consumers to be involved with their own healthcare. We want them to utilize the tools. And that goes for anything as simple as go into the drugstore, look at the tests that you can buy, the A1C tests, the STD tests. Just go into a Rite Aid or a Walgreens or a CVS, ask them where the home test kits are, and you'll see celiac, rheumatoid arthritis, A1C, for your blood sugar. You see them advertised on TV. Everlywell is a big provider. Any number of mail away kits, Cologuard, if you're thinking about getting a colonoscopy and they give you the, do it in a box and send it away. You have to go in, log in, register your kit. There's a EULA agreement. You're agreeing to have your data transferred. People are reluctant to do that because they're putting data into the cloud. If they knew they had a way to control that data better, they're more likely to use those, and people are more likely to get those preventative diagnostics done. And that's a good thing for the world of healthcare. So
Thank you very much.
Pass the bill.
Does anyone have any questions? Representative Tur.
Yeah, just one question, because the previous testimony, we heard that this pertains to services but not to products. And given the Q Health that you mentioned, my Aura Ring is at home charging, you know, a device that's also a service.
Bingo.
Does that preclude that kind of distinction, or do you see it a workable divide?
Funny enough, a product like the Q Health, they basically give you the device. It's in diagnostics, they call it almost like a reagent rental model. They just give you the hardware and you're buying a subscription for it. And then you do pay for the consumable test kit. So there is a service, like they perform so you buy the little consumable test kit. They give you, I'm sure there's some capital costs that they build in, because I know the little test kits don't cost, you know, as much as they charge you for them. And then there's a subscription service. So it's kind of both. That makes sense. So it's not.
Could we
So-
focus
Oh, I'm sorry.
more on the bills? Can you connect your question to the bills before us?
Yeah, I'm sorry if I wasn't clear. I was just trying to determine whether this distinction that's in the bill between goods versus services is something that will become unworkable going forward.
So the data service. So let me try to clarify. They house your data, and these diagnostic providers. I'll speak to diagnostics specifically. You know, lab tests, home health kits, any of those, and there's just hundreds and hundreds of them, from cholesterol tests to all kinds of things. You know, from little finger sticks smeared on a card, send it away, get your cholesterol, celiac, all those things. They house that data. They'll send it to your provider. They'll track it. They'll advise you. And many times the big moneymaker for them is not that you paid $50 or $150 or $199 to see if you may be on the celiac spectrum, right? So you shouldn't eat wheat. It's really that they want to sell that data to all the people that sell drugs that can help you, or all the people that sell insulin if your A1C is high. So the real key to them is the data monetization, right? So for you to have control of that in some fashion, you may agree that you'll limit the resale of your data, limit some of it, right? But it'd be nice to have complete control of that. You'd be more apt to find, like, say, I would personally feel better to know what my A1C is, let them share it with my doctor, but not let them share it with the entire world of big pharma, or every insurance underwriter. See where I'm going with that?
Yeah. So you don't think that having a product tied to the collection of that data leaves a loophole for people to get around this, because they could say, well, it's not a service, it's the good that I sold you.
I guess I don't know for sure, and if there's a loophole, maybe we should close it.
Is this not something that the European governments have addressed, and we see it indirectly in some of our use on our computers, where you have to consciously agree to how the data is going to be used?
I do believe the MDR does. The med device regulations in Europe does address it differently, yeah, and more stringently. For instance, you can't email people. You can't even so much as direct email marketing in Europe for medical devices and things. So
Right.
yeah, they're a bit
And,
more stringent.
Unfortunately, our country has not done that, and so for those of us who refuse to participate in all this corruption of our society, have limited access as a result. Any other questions? Thank you very much for taking the time. Sorry we missed you before, and glad you're here now.
Thanks.
Who else? And I see the Municipal Association. Good morning.
Good morning. Thank you, Madam Chair, for allowing me to comment today. Nate Grays with the Municipal Association. I did sent a rather lengthy letter to the committee last week, or subcommittee last week, that hopefully you all received. I'm not going to go into great detail there. I'm certainly happy to answer any questions anyone may have about that. I want to thank you for the opportunity to comment after you've all discussed this, because I think I better understand maybe where the committee's going here. I certainly agree with you, Madam Chair, with the DMV example that you gave earlier, that packaging that information together and reselling it doesn't seem like something that government should do. And I don't think we have any objection to prohibitions of government doing that. Just one note on that point is you may want to make sure that information held by the government that could be obtained in other ways, such as through a right to know law example, is also that's also clear, that there's a harmonization between kind of this expectation of privacy that you're working on, along with the protections already in 91A. As far as I guess just a brief summary of some of the issues we raised, and I did talk with Representative Irf back in January and February about this, and we had some really good and I think productive conversations. We would like to see in House Bill 314 some clarification of the definition of third-party providers. I note in my letter that some of those listed providers, utilities, really are government-owned or interact pretty extensively with the government. There's some provisions in our law about exactly how that, non-paid payment of water, for example, bills would be collected through your local tax collector. And we just want to make sure that that really goes to our core point, which is we want to ensure that government continues to function. That's really what we want to see happen. And we were also hoping that there could be clarification on what the prohibition on government was. That's that Roman numeral 2 that has been discussed extensively, just to ensure that it's clear that we're talking about information that's not publicly available. I think that really just goes to some of the committee's discussion about the structure of the bill. Might be a little confusing for those who are not well versed in the law, which may be the case for many of the volunteers running local government. And we just want to make sure that when they read it, they understand what they're supposed to and not supposed to do. And I guess the last point is that has been discussed briefly here today, but I think that there has to be some sort of intent or a skinter element for the violation on the government's behalf. We don't want to see a situation where a third-party provider has decided to give the government information that either is beyond the scope of the government's request or is otherwise in violation of the chapter, that then results in the government being liable for any sort of violation. Certainly, it's the case as I believe Mr. Kirk described. If we have a very specific thing that the government is specific piece of information the government is requesting, whether that's through a warrant or whether that's through a subpoena or whether that's simply just a request, and for whatever reason that third-party provider decides to hand over the entire customer folder or file to the government, the mere fact that we receive that isn't something that we think should result in liability for the government. Presumably, whoever's in charge of that case is going to properly dispose of that, particularly if it's a criminal case, properly dispose of that in accordance with existing evidentiary retention requirements at the conclusion of that case. And we don't want to give rise to some sort of liability. That's obviously different than if the government goes out with bad faith and requests information that they know is in violation of the chapter. So we think that's a distinction that should be made just to clarify kind of where that lies, and that's really my last 3 points in my letter. Certainly happy to take any questions anybody has.
Thank you very much. Questions? Questions? I don't think so. And thank you very much for sending that letter to us. The information that comes in is helpful as we try to figure out where we go from here.
Thank you.
Anyone else here who would like to speak? Well, that's a surprise. Okay. Thank you all very much. So now we have had before us, we have two bills, and Chairman Lynn has articulated a very strong and clear argument of why he believes that the bills are related to each other and might, in fact, benefit from being combined in order to avoid conflicts in each of them, although we understand that one is dealing with the government and one is dealing with private.
Madam Chair, could I make just one other comment?
Absolutely.
You know, I do think, I guess what I would say, I do think that that we should at least explore the possibility of combining the two bills. But the other point that I would make is this. My sense, and obviously my sense may not be consistent with the way the committee looks at it, but my sense is that 255 is, if not ready to go, very close to being ready to go. I mean, I could see from my perspective, a few minor things that we might want to change, and I think some of them I had proposed in amendments. But I think that's very, very close to being ready to go. 314, I think, probably has much more work to be done. And although I think it should be, I think it would be worth looking into combining it with 255. I wouldn't want the amount of work that might be necessary to do that to sort of undercut the importance of 255, because I think even as a standalone bill, that's very worthwhile, and we ought to consider that on its own if combining it with 314 would mean that both of them we didn't move forward on either one of them.
Let me just talk for just a moment about timelines. We have retained two bills. We have, I believe, until November 16th, something like that, to vote on retained bills. And we can do anything with those retained bills. We can that we can ordinarily do with a bill. We can vote or to pass as it is. We can vote or to pass with an amendment, and we can vote an expedient to legislate. And of course, we do have the last option, which probably nobody wants, which is to keep for further study, which would be next summer. We would look at this again. And so that we can do, and in carrying that out, we can keep the bills separate, or we could, through the amendment process, combine them. So that's one part scheduled. The other thing to keep in mind is that we have from September 11th to 15th to file new legislation. If we were to decide that, if any individual were to decide that that's the route they wanted to take. And then there is a third route, and that is as a committee. I believe that, I don't believe this has changed, perhaps Ms. Grant could tell me, that we could apply to the Rules Committee to ask for permission, for example, to introduce a new bill that did not conform with those schedules I mentioned up until now. So we have a lot of flexibility, and we know we have the summer to do, to the extent that anyone is willing, to do the hard research that is necessary. We certainly know that although a number of the people in the room did not volunteer to speak today, that they have indicated to us formally and informally that they are available to help if we need additional information or additional guidance. And so we have those resources to work with. This committee would not meet again until September, and then sometime between then and mid-November, the full committee would meet at Chairman Lynn's call to vote on all our recommendations. So I just want you to understand the time structure. I did see Chairman Kirk raise his hand. Did you want to add something? Could you please go to the microphone, because I know how much you like this, but these are all on video or whatever it is.
Thank you, Madam Chairman. When you first called upon me, I thought the subject before the subcommittee was 314. And it seems as though you're not taking separate testimony on 255. But I do have some comments on 255 if that is of interest to the committee.
Yes, it is. We're interested in testimony on both.
Thank you. With your permission, may I hand out something to committee members?
Of course. Actually, you may hand it out even without my permission. Thank you.
Senate Bill 255, as I understand it, is basically a bill that has been promoted throughout the country by Microsoft Corporation, and it's been adopted in several states. I think Connecticut is one of them. I'm not sure, or I'm not privy to why they're doing this. Most large corporations come in to oppose a state when it proposes to regulate in a particular way, such as California has done, because most of these large corporations want uniform regulation throughout the United States and would prefer to have Congress legislate and preempt states from taking a different position. For reasons known to Microsoft, they've taken a different approach, and they are going around to various states, I think all of the states, to try to have this particular legislation passed. Obviously, Microsoft is a for-profit business, so in some way, this bill is important to their business model. But what that might be, I don't know. I support the informational privacy provision or aspect of this bill, but not its current form. It needs amendment, 4 of them in particular. First, the way the bill is set up, every company that is subject to this bill can have its own method for opting out and its own procedures for opting out. As was alluded to before, with the exception of Representative Lynn, most of us are not going to take the time, even if we want to opt out, to understand how it's done in each of the different companies, because they will all have different ways to do it. How many clicks will be required for us is unknown. So one of the things I would suggest is that there be a uniform way for people to opt out of the use of their personal information held by these companies, so that it's easy for us as human beings. We have very little time. We don't read these long descriptions. It's hard for us to understand how to go to column A or menu A and then finally wind up on menu B and then actually opt out. if you were to do that, it would produce a method, at least, that makes it possible for people to take advantage of the options that are before them. Whether it's intended or not, our lives are too busy and too fast-paced for the legislature to require all of us to go through this process to opt out. So an amendment, I think, needs to be drafted to simplify the process and make it uniform. That's the key thing, uniform. Secondly, and not as important as the first, this bill covers very few companies. You have to have at least 100,000 New Hampshire subscribers before these provisions apply. So most companies in New Hampshire aren't going to be affected. This really applies to larger national companies. I'm not sure that that's fair. As consumers in New Hampshire, why are we saying that our information held by national companies should be treated differently from information held by New Hampshire companies? Why shouldn't I have the right to opt out from a smaller company, maybe just a New England company or a unique New Hampshire company? Why only from the national companies? Now, you can imagine why Microsoft has done this. It eliminates a lot of potential opposition. But for us, as consumers, the distinction is not very clear. And I don't think it's a good distinction. Thirdly, this bill is an opt-out bill. Whatever privacy protections are in it, you only get them if you act. If you don't act, you don't get them. Well, we all know informational inertia. I would suggest that if you're really interested in protecting privacy, that you make this an opt-in. If you make this an opt-in, the First Amendment is unnecessary because all of the companies will do their very best to make it absolutely as easy as possible to opt in. What should be the default position? How do you want to protect privacy in New Hampshire? Do you want to make our citizens work for it? Then this bill does. If you want to make it the default position, you need to change this from opt-out to opt-in. Finally, the enforcement provisions in this bill benefit the companies, not the citizens of New Hampshire. Number one, there's no private right of action. Number two, it's only the AG who can enforce this. Number three, when he enforces it, he has to give the company 60 days notice. If the company corrects the problem within 60 days, he can't bring the enforcement action, a get out of jail free card. If I were in Microsoft, I would think that passage of these bills would enable me to tell consumers that Microsoft is very concerned about their privacy and has done a lot to protect it, when in fact, this bill does not really protect privacy. Opt-in is complicated, opt-out is complicated, and there's no enforcement. So even if I opt out and Microsoft chooses, or some company like Microsoft, chooses not to honor this or in some way makes a mistake, I can't do anything about it. I can complain to the AG, but you know the AG is overworked and understaffed. So if you're going to pass the bill as it is, at least give the AG the staff and the money to enforce this. I appreciate your attention. I'd be pleased to answer any questions, but the problem with this bill is it promises but doesn't deliver. And that really disturbs me if the legislature were to go along with that position. Thank you, Madam Chairman.
Thank you. Questions? Representative Tura has a question.
Yeah, thank you, and thanks for that testimony. Focusing on the first sort of provision of an amendment that you had suggested, and that resonates, I think, because it is a very complicated world and having to learn every company's separate rules. But did you have a
Eric,
sense?
move your microphone closer.
Oh, I'm sorry. Sorry. So the question was, do you have a sense of how that uniform process would be established by what entity and whether or not our passage of something like that would influence the way all these existing companies are already operating?
I wish I had the knowledge to answer that question. I don't. I know there's a problem. I don't have a solution. That's just beyond me. But there are people with technical expertise who you should be able to contact who can provide those kinds of answers.
Any other questions? No? Thank you again very much for this information. I'm going to ask a question again, and I bet I'm going to have a different answer this time. Is there anyone in the audience who would like to speak now? Much to my surprise,
Kirk, but just so I didn't forget it
that's all
in the
right.
back row. Thank you for the opportunity. My name is Curtis Barry. I do represent Microsoft and had not intended to speak today, but as they say in the political debates, since my client's name was invoked, I felt an obligation to respond to some degree. I'm not an expert in the content of Senate Bill 255 to the extent of how it's been developed over the last several years, and this have not been involved with the stakeholders who have done that from state to state, but I can respond to a number of things. One thing right off the bat to Representative Kirk's enforcement issue, 2 points. One is I don't think he's had the opportunity to know this. In the budget, and I think I sent this all to you on an email, in the budget that was signed last week by the governor, the Senate had added provisions, 2 changes to House Bill 2 and 1 change to House Bill 1 that addresses the Attorney General's enforcement concerns. Those changes specifically are adding data privacy enforcement to the laundry list of obligations of the Consumer Protection Bureau. The second is, as the Attorney General's representative at the public hearing referenced, they're funded by what they call a settlement fund that's currently in statute capped at $5 million. The balance goes to the general fund. The Senate amendment that was adopted increases that to $6 million. So they have an extra $1 million to play with. And then in House Bill 1, the Senate added 3 positions, and these were changes that were worked on. I hope I'm not divulging any confidences, but between Senator Rosenwald and a representative fairly high up in the Department of Justice. They've added 3 positions, a paralegal, an investigator, and an attorney, specifically to address the enforcement issue. The second point I'll make about enforcement, and it needs to be reiterated, is as Mr. Harkins, who works for Microsoft, testified at the hearing, there is no issue that has killed more bills, privacy-related bills, in this country, specifically this model, than the right of private action. And if you look at the chart that was referenced earlier, you'll see that the vast majority, if not all except California, that have been enacted do not have private right of action. I like to work on things, I like to say I operate in the realm of the possible. I like to work on things that we can pass. And I do not have confidence that this bill would pass with a private right of action in the language. So specifically, back to some of the Representative Kirk's comments. I would not characterize this as a Microsoft bill. I think if you look at the coalition of folks or folks that have testified in favor of this, both in the Senate and the House in New Hampshire and in other states, there are a lot of companies that support this bill. Representative Kirk referenced if I understood him correctly, he questions why we would want to pursue legislation from state to state because we would want to seek consistency and it should be dealt with at the federal government. That was Mr. Harkin's testimony. We prefer, Microsoft prefers, I'm sure a number of other stakeholders do, a federal solution. That is not forthcoming, hasn't been forthcoming. Thus, like other issues, people who support this, particularly state legislators who value privacy, brought forth legislation on a state level. Maybe that compels the federal government to act, maybe it doesn't, I don't know. So it is on the consistency from state to state basis that people will support this. Representative McHugh cited that as part of his own support. Some of the stakeholders in the private sector agree. State by state laws need to be as consistent or uniform as possible to make it easy to comply. But Representative Kirk's proposed amendments don't do that. In fact, when you look at the chart, and I can give you some updates, I made some notes this morning. Since the hearing, Maine has introduced a bill that is close to this model. Delaware has introduced a bill that's close to this model. And the states that have enacted since the hearing include Montana, Texas, Indiana, Tennessee. I think as we indicated earlier, these are not all red states. They're not all blue states. They're a good mix of red and blue states because people across the country value privacy on the part of their consumer. And I think the last comment I'll make is I disagree that this is ineffective because as I sit here today, I do not have rights over the personal data that a private entity company holds, my personal data. This bill gives me rights. So I'm happy to answer questions to the best of my ability.
Thank you very much, Mr. Berry. We have a form here that the International Association of Privacy Professionals last updated 6/19/23, but the information you just gave us differs a little bit in terms of, I believe, unless I miss, in terms of laws signed to date.
Okay, so the IAPP, their website has two links that are near each other on their website somewhere under their resources. The one I'm referencing is the map, which, and I believe I've sent both links. One is the chart that will compare state by state, what are the elements that are similar, you know, the X's or the check boxes. There's also a map available, color-coded map, that displays which states where a bill has been introduced, which states where a bill has crossed to the second body, which states where it's passed, and which states where it's been signed into law, et cetera. A few other changes, for example, New York and Vermont had bills introduced, I believe, but they're not currently active, so their status has changed over time.
And what were this, in fact, what were the new states that you've added to states where?
So, yep, the
signed into-
states where it's signed into law that I believe were since the public hearing on Senate Bill 255 are Montana, Texas, Tennessee, and Indiana.
Thank you.
You're welcome.
Representative Andrews, did you have a question?
Yeah, thank you, Madam Chair. I do have a question. Mr. Kirk's proposals, the way I heard you testify, are not really consistent with the laws of the other states that they've passed. What if we did pass this? How bad is it going to be for the companies out there?
I can't speak for, you know, all of the entities, and I wouldn't answer on behalf of Microsoft to that question until I ask them that question. But other than to say it would be inconsistent, and it's something that I've heard for the last 8 months or so working on this model with sponsors, et cetera, and stakeholders, is that consistency is of utmost importance. Thank you for the question.
Anything else? Thank you.
Thank you
very
for the
much.
opportunity.
I'll ask once again, is there anyone else in the room who would like to share information with us, all in hopes that it's going to help guide us as to how we're going to proceed? I see no one else who is interested. So now it's back to us. And where do you want to go from here? Other than to lunch, that doesn't count.
when would we take up some of, like with 255, some of the small tweaks and things like that, some of which may be big tweaks, but when do we take up the discussions around those tweaks?
Well, as a committee, following House rules, we may not meet again until September. That does not mean that, conscious always of 91A, that one or two of us might, not work on avenues that we want to pursue. And by the same token, again, with less than a quorum or individually, we know that people in the public who have views that they will want to share can share that with us. We would not come together again until sometime, relatively early in September. But my hope would be that when we came together in September, we would be able to bring to the table as individuals a much more developed view of where we want to go. We have the two threshold questions. Do we keep these bills separate, considering each of them, but considering them separately? Or is there any benefit in terms of creating the best possible legislation? Do we combine? And that obviously is a threshold question. And then we have the comments that have been made, informed comments that have been made by a number of people, Municipal Association, Microsoft, current and former legislators, and the members of the committee to help inform us. What I don't want to have happen, and I have no control, obviously, is that we say, okay, fine, we've done this, and now let's put this all in the back of the pile of things to do, and we won't look at it again as individuals until September, because these are complicated issues. And I would think that they do need some thoughtful involvement. And one possibility is that as individuals, or perhaps as two of us, work on specific amendments that could then be reviewed by the committee, not necessarily with the expectation that they'll be accepted, but with the expectation that it gives us something to focus on to decide where we want to go from there. Or we might find that someone has just the perfect suggestion. The timing is awkward. I would rather that we could say, next week, let's get together again. But for some reason, I'm not the speaker. And so, but I do live by the rules. So that's my situation. Chairman Lind, first I see Representative Andrews has.
Thank you, Madam Speaker.
No.
What, Madam Chair, sorry. What I see
so
here
much.
is two great bills for privacy, but I'm questioning in my mind, if we combine them, would we try to make them too complicated? It would be a complicated law. Personally, I think we should keep them separated. I do think they need to be tweaked, both of them, and make sure in the end that we're not worried about outside businesses. I know they have to be protected, but I think our big thing is the protection of the citizen. Because where I use a computer, like I get a lot of emails I don't want from companies, and I just at the bottom it says unsubscribe. When it comes to working with a company, I just don't know why it can't be that simple if you don't want your information shared with somebody. And I just think we need to work out things, and I think it's going to take a little time. Thank you.
Thank you. I know so little about all of this, but if I could add one comment, if you got that initial email as kind of a blind stab in the dark from whomever sent it, and you mark unsubscribe, what you have now done is given them your email address. I just want to point that out. um, Representative Alexander.
Thank you, Madam Chair. I think that 255, I just go back and ask myself why is this bill being introduced? It's to create uniformity across all states, but what's stopping companies from doing this already is my question. And I feel like there's not a lot of like incentive for us to even act on this right now because there's nothing stopping a company from doing these things in here to begin with. What concerns me more is the citizens of New Hampshire passed an amendment concerning government entities, nobody else. I think what we should, I don't want to combine these, but what I think we should do is start with 314. I think Neil Kirk raised a lot of great concerns with 255. If I wasn't against it before, I probably am pretty. I think there's some changes need to be made in what I looked at on here. But I do want to look at 314 a little bit more. The biggest concern I have with 314 is the enforcement area of it. I think that we can work on some language there that would be helpful for me to get on board. But I personally, like I said before, like to start with government and start with ourselves before we go anywhere else. And you know, I have a sneaking suspicion if 255 passes enough states and New Hampshire doesn't act, I have a feeling that all those big companies will jump on board anyways. So thank you.
Thank you.
Yeah, I would say after listening to the details on the two bills and the way that they protect privacy, they seem fairly different. That the 314 bill basically talks about the collection and keeping of data and when it's allowed. The other bill sort of gives consumers a lot of individual control over a lot of aspects of the specifics of how they can control that data, what they can do with individual pieces, whether they can opt out of some things and not others. So it seems more difficult thinking in that way to combine them, even though they both sort of address necessary pieces of the question of privacy collectively. So, you know, I do sort of think I actually think the 255 one probably is further away than the 314 in terms of because it does seem like there's some changes needed, even just to make it consistent with the way it's done in other states. So that would be my general thought right now.
So my understanding, and tell me if I'm wrong, is that the point that Representative Andrus presented to us, that they're separate bills, and that there's reason for them to be separate bills. Is that something that at the moment, understanding we're not committing to anything now, we're not voting on anything, that would be the general consensus of the group, that they are, yes, Shel? I'm sorry, Representative.
That's okay. The only concern I have with 314 is if there's any overlap in 255, and if there's anything that would be, you know, contradictory, and just to double check and make sure that there wouldn't be anything contradictory, say in 255, that would oppose 314. And then the other thing with I think they should both be separate, but on 255, the idea of opting in as opposed to opting out should be potentially researched, I think.
Should be considered.
Yes.
Representative Lynn.
Yeah, I was gonna say, I have no problem with keeping them separate, with the exception of the very issue you just raised we need to be if we're gonna do that, we just need to be careful that we don't create sort of a conflict between the two. Because, for example, 314 as originally drafted without considering any amendment, would appear to create an expectation of privacy in personal information that may be different than what 255 talks about, or at least to the extent that it may apply to information held by private businesses, for example, that are not covered by 255. Maybe that's a conflict, maybe it isn't, but I think your point about just being careful that we don't create a conflict is important.
Thank you. Anything else? I like to be a problem solver, and I'm feeling a little bit at 6s and 7s now. I see that there are a lot of questions before us that do need answers. I see that the official structure, I think, gets in our way. But I don't personally feel comfortable asking the speaker if we could have permission to meet again, because there are a lot of reasons why they do not have us here, including the fact that the staff needs time to do all the work we haven't let them do, that the people responsible for the building need time to make essential repairs, and we all need a cooling off period, perhaps. And I guess my problem is I don't want July and August to be dead time. Yes, Representative Devine.
So the big question for me now is if there was a comparison between both bills to make sure that they don't conflict, how would one go about doing that? Who do we reach out to? Is there somebody already in place to look at that? Whoever drafted these other bills, and working together that would be my question.
My initial response to that is we have identified in each of the bills areas where we might want to make changes. Nobody's signed on the dotted line yet. So to look at the existing language where there might be conflict might not be the best way to handle it in a timeline, because we might want to get a little closer to the final language that we're considering before we do that. And we do have a couple of months, in September and October. I can well imagine that Representative Lynn has already identified 16 amendments that he's going to propose, some of which will incorporate the first 10. But, and I say that, as he knows, with great admiration for his commitment to this committee and to this work, that I appreciate very much. But does anyone have any suggestion to help me get past my feeling of how to best use time?
Well, could I make this suggestion, since I'm as I've said before, 255. I'm kind of comfortable with it the way it is, and I understand that there may be change. People have different views, and that there may be changes, and that's fine. Um, so so my preference would be, and I would volunteer to do this. I um, would suggest that maybe I could work with Representative Erf and former Representative Kirk, if they're willing, over the summer to try to make some changes to 314 that would, maybe be helpful to address some of the issues that have been discussed, and try to come back um, to the committee in September with some proposed language, some proposed changes. And I'm wondering if those who have greater concerns about 255 might be willing to do the same with regard to 255.
Thank you very much for that. Is there someone who would like to, I mean, I know you'll get some help on this. I would be happy, to take responsibility for looking at 255, and now that I have done that, I see two others, and let's see, one.
Madam Chair, I don't want to take the lead, but there's too much on my plate. But if
1, 2, 3, 4, there's 6, 3. Woo. I think three of us can do it because we're not a majority. And so we can, and we're not going to vote. So we can do that. Okay? Very good. And we'll know that in name, I'm the lead. De facto, it will be Representative Alexander. Okay, anything else that we should discuss right now? Do people feel comfortable that we've accomplished something? If this were easy, we wouldn't be here. We would have already acted. Okay, then I say that we are finished with our subcommittee on 255 and Senate Bill 255 and House Bill 214, and we will meet again as a full committee in September. And thank you all very much for helping us work this through.
The time is 1:20, and I'm going to go ahead and open up the subcommittee work session on House Bill 362-FN, which is an act relative to complaint procedures in cases before the Commission for Human Rights. I do apologize for our delayed start. We went to the Human Rights Commission office and we were a little bit delayed in getting back. So I wanted to kind of open up by giving a little bit of an overview in what we just heard, because Rep. Andrews wasn't with us for that session. So I wanted her to have a little bit of background. And then I want to kind of open it up if the committee has anything to say, and then if anybody else would like to speak. So overall, what we heard was that the number of cases, I guess I can give an overview of just everything to start with. The number of cases that they currently have pending right now is 230 cases, and their oldest case is from February of 2022. They currently have 5 investigators, and they did just receive budget to hire 4 more investigators. They get about 16 new cases per month, and the number of cases that they're closing per year averages around 225 cases. So they're getting through, a pretty big chunk of cases. And it seemed like the data that we got from 2022, the number of complainants that removed cases to court was 38 cases, which was 12.8% of the overall number of cases that had closed. The number that the respondent removed was 22 cases, which was 7.4% of the overall number of cases. So, and then the number that was closed with no probable cause was 34%, and the settlement percent was 24%. And then the overall failure to locate the party or failure to proceed or it being withdrawn was 17%. So it seemed like the number that are actually being removed to go to court isn't that high anyhow. But the most interesting piece for me was hearing that in the EOC, federally doesn't allow a respondent to remove the case because they consider it retaliatory. And New Hampshire and Rhode Island are the only 2 of the 50 states who do allow for a case for a respondent to remove the case once the process has begun. So that was kind of the data that we found that I think is really kind of the most important pieces, because I do think, with their increase in staff and whatnot, that they are making headway into their significant backlog, which I think was part of the reason why we initially wanted to do this subcommittee session, was to make sure that was the overall arching problem of the committee being so backlogged being addressed. And it seems like with the new budget and the fact that they are having so many new hires, in addition to the 4 new investigators, they're also switching over 3 employees from part-time to full-time, including a secretary, a paralegal, and the office manager will be switching from part-time to full-time, and they'll also be adding a part-time intake coordinator. So with that said, I'd like to open it up to the committee if you guys have anything else that you kind of wanted to add. Rep. Horrigan?
Yes, one thing is the number of cases that goes to a public hearing before the Human Rights Commission. They have 7 commissioners and 3 sit on a panel, is very small. That's about, I think there's just been 3 this year. So apparently that's partially by design. They encourage the respondent, the complainant and respondent to settle on their own whenever possible. And that's the most common outcome, and followed by sending it to federal or superior court. And also even a large percentage of them are found no probable cause, but that doesn't necessarily mean the case was frivolous. Sometimes the worker has it's a legitimately bad work situation that's not purely that's where there's fault on both sides, but it doesn't, fall within the rubric of the employment law. And that is like most of what the commission deals with other issues, but it is like, actually, I don't have the exact percentage here, but is primarily employment law that they deal with. They also deal with housing and public education and public accommodations, and also there's a new Pregnancy Fairness Act that came in just the last year or so. So it seemed, I mean, of course, they're the ones putting it didn't seem to be a organization in crisis, so it seemed to be going well, and they are expanding. So
Thank you. Does anybody else have anything to say?
Thank you, Madam Chair. I would recommend recommend to the committee going forward with the legislation, the proposed legislation, and getting that done. As far as the Human Rights Commission's performance, I would like to wait until we have the performance audit to make an assessment. I don't feel it's our place to micromanage the Human Rights Commission. So I just feel like, they've shown us what they're doing. It looks reasonable, it looks fine, but let's get the performance audit done. Thank you.
Thank you, Rep. DiLorenzo. Rep. Andrews, did you have any questions? Because you weren't able to actually be there. I'm not sure if kind of the overview, and one number that I had missed on giving out was 5% of the cases are also closed because of no jurisdiction, just to kind of add up. I was just going through to make sure my numbers added up to 100%. Do you have any questions about?
Thank you. Not really. I mean, my main concern is, and I think the performance audit might help us in where they're going to hire more people, is to make a quicker process for the claimant, because waiting 2 or 3 years to get an answer is not acceptable. I don't care what anybody says. And the process has to speed up. But I think what we have to do, where they're going to hire more and they have more money, we have to give them a chance to see what happens. Thank you.
I completely agree with that. And that was, one of my biggest reasons for wanting to retain the bill, was that it seemed like the cases were taking so long. But after going in and hearing kind of what they were doing, and the fact that they did get the budget to essentially almost double their staff, and I think we need to see where things kind of go from there before adding in any new legislative or statutory changes that might try and make it expedite things, because we don't want to have any unintended consequences with that. And I didn't really see any areas that, if it seemed like if there actually was staffing available, there would be no reason why the cases could not be closed within even a 6-month time frame. So I do think once the backlog of cases is caught up, that we will be seeing a much better turnaround. And I am not sure that there's any other additional changes that necessarily needed to be made. I did think it was definitely a very interesting piece that we're one of only 2 states who do allow the respondent to remove it. So for me, I'm kind of in agreement with Rep. DiLorenzo that the original bill that was in here, seems like it would make sense. But I would like to hear from those who are before us. Rep. McLean, you were part of the original study committee. Do you have anything you wanted to add?
You've pretty much covered the ground that we did in the committee last year. This is verbatim language from SB 296, which came to us last year, and this was total bipartisan legislation with support from both sides. And I think I would like to see this go forward with the original language. We held it over last year again for some of the same concerns. While we thought, legally everything is right, the U.S. Supreme Court says the claimant gets to choose the forum, and you talked as well about the EOC and the fact that we were only one of 2 states. So we said, yeah, we think it makes sense. But at that time, we were hearing horror stories, and we says, if we take away the right of removal by the respondent, is that just going to crush something that is already burdened? And we had a much harder time getting data. You apparently were able to get lots of great data out of them, but we had a very hard time getting data. But ultimately, we came to the same place that you're at. They're looking at taking in, at that time, it was, say, 20, 25 cases. Now you're saying it's down to 16. And the data that we had was the rate of removal wasn't as much. We were, I think, talking about maybe 10 cases removed. But even at 22 cases being removed by the respondent, it's a percentage that I think the Human Rights Commission can absorb. So based on that, I don't want to micromanage. They're able to fulfill the language that is required in the bill, and with the budgetary additions that have been ongoing, it sounds like they're able to kind of bust that pimple much more effectively. So I think, all things being even, that's because I think it's just a question of fairness as far as that goes. There is a performance audit that we did petition the LPAOC for last year, which looks like it's going to go forward, which I think would give even more data and maybe highlight other opportunities. But I don't know that this is something that the subcommittee can really do. I did quickly look over the amendment from Representative Lynn, which is kind of allowing for the respondent to remove after the claimant does. So that would be, if the claimant's allowed to remove after 180 days, this would give, if I read it correctly, the respondent the right to remove about within 60 days after that. But I think that gets back into the problem of you're allowing either party to choose the forum. And really, the burden of proof is on the claimant, and so they get to choose the forum. It's not equal with respect to choosing the forum. And so I don't really have anything to say based on all the research you've done, other than that I would like to see it go forward with its original language intact.
Thank you. Does anybody have any questions for Rep. McLean?
I have a question for you.
Oh,
Okay.
okay. Go.
I just wanted to clarify the information we were provided about the EEOC and what it is that they view as being retaliatory.
Having a respondent have the ability to remove a case.
Without the claimant also having the similar ability?
No, the claimant can have the ability because they have the burden of proof. It's I think the idea behind it was that they want to prevent discrimination, right? And the thought is that a company may have the resources to go to court and whatnot, but an employee may not necessarily have those same resources to actually be able to rise to the level of filing in court and hiring an attorney and all of that. So the idea of the respondent being able to then take them over to court and then they'd be, pro se over in court was kind of seen as this human rights is supposed to be providing them an option that's, I guess, financially reasonable within their means, that a lay person could be able to enter in a case to them, but a lay person may not necessarily know what to do if something was sent over to the court. Did you have something, Rep. DiLorenzo?
Yes, thank you, Madam Chair. And Representative Manos, I believe that one of the reasons that there was concern, one of the things that they were concerned about, as a committee, was that with the respondent only having the right to move the case to Superior Court, the issue is that there's a backlog at the Superior Court that we know about, and doing so, the respondent could do it, like remove it like at the last minute, and that would delay the whole process. So that's one of the things. But I think that with this amendment, it's almost like a seesaw effect. Like we're saying that the complainant would have the right to remove it to Superior Court, but then after 60 days, the respondent would have the right to remove it. So it's almost like, you know, like a seesaw, and it would be on, I think it would be on balance.
Oh, Madam Chair.
Yes.
So I think the reason that the respondent has that, sorry, the claimant has that right at the 180 days is because everybody has to file at the Human Rights Commission. You have no choice. So if it's this kind of a case that you're bringing that has to do with being a member of a protected class, you have no choice but to go and start at the Human Rights Commission. And so for many people where there's a huge amount of complexity to the case, they may choose to retain counsel, but they cannot leave until the 180 days is done because they have to file there first. And the reason that the EEOC and others have really not been happy about this and view it as being retaliatory is because it's not that you have a finding of probable cause and then the respondent removes it as an appeal. They remove it and it's a de novo hearing. So it wipes out everything that came before. So I put a news article from Union Leader, which Marissa Chase sent over to me, I think, half a year ago, which talked about a case. It's an example of how this is used. So a gentleman at Market Basket, he took a complaint to the Human Rights Commission because he felt he was not being given a full-time opportunity at Market Basket, and he claimed that they said, look, we reserve those for younger people. And so it went to the Human Rights Commission, and the Human Rights Commission, after 2 years and 7 months, said, yes, indeed, we find that we're finding in favor of the claimant, at which time Market Basket removed it to the Superior Court. But not as an appeal, but as a de novo hearing. So it was removed without prejudice, and basically everything starts again from the very beginning. And I think that is why the EEOC and the U.S. Supreme Court viewed it as being retaliatory. And I think that's why only 2 states allow it.
Thank you.
And I want to thank Representative McLean for all of his work, you know, over the work sessions last summer and continuously up to this point. He's been really fabulous. He dug in and wrapped his arms around it, and thus we have a bill to pass. Thank you.
Thank you very much. Would anybody who's in the audience, I guess, in the gallery, like to speak?
Thank you, Madam Chair, members of the subcommittee. For the record, my name is Dave Jube. I'm a Senior Vice President for Public Policy with the Business and Industry Association. And you'll recall from the hearing that we testified in opposition to this bill and had a number of attorneys that also testified opposing the bill. And they have both experience representing both claimants and respondents before the Human Rights Commission, and they had experience in cases before the EEOC. I guess my request at this point is to encourage you to delay a decision on this until the fall, and I'm asking that for a couple of different reasons. One, in the fall, we should have the performance audit. I believe that can be completed in the fall, and we'll be able to see what that report says. We'll also have 3 or 4 months experience with increased staff at the Human Rights Commission, and we can assess what type of hopefully positive impact that is having on the more rapid adjudication of cases. But I'd also like you to hear again from the attorneys that were present that have experience, because I just want to make sure that all the information you're receiving about the EEOC and how other states deal with this issue is completely accurate. It could be. I'm not an attorney and I don't have experience with this issue from other states, but moving your decision making until the fall, which won't impact how this gets reported out from the committee next session, would allow these attorneys to come back in and answer questions from the committee. They'd be here now, except we're in the middle of summer. One is in somewhere in Italy, one is somewhere in California, and the third I just couldn't get to respond to my email, so I'm not sure what her status is. But I know the summertime people scatter, and so we understand you'll make a decision eventually. It may not be what the BIA would prefer, but that's how things go in the legislature. But I would at least like to make sure your decision is based on the most current and accurate understanding of this issue as it applies in New Hampshire and also around the country, and also with the EEOC. So that's my request.
Okay. So whatever we decide here today is just as a subcommittee kind of our finding, but the entire committee, the body of 20, would still have to vote on what they wanted to do with the bill before it went on to the House to move forward. My only thing is, I think we had originally opened this up because we were very concerned about performance and whatnot, but it seems like some of the concerns have been addressed. And I think that that's something, if the audit committee were to find something, another bill could be certainly opened up to address something related to that, but I'm not sure that it would change how we would proceed with this. And I hate to put you on the spot, attorney, but would you be able to look for us and see if that is accurate information about the EEOC and us kind of being one of 2 states that only allow that? Is that something, I don't know if that's an easy thing to look. Okay. Okay.
And if I could respond, I've been doing this for a long time, and the recommendation from this subcommittee will be critical in how the full committee looks on this issue. And so it's important to me that the subcommittee has all the information available so that they can make the right decision and what they believe is the right thing to do on this bill. So again, I would ask that you resist the temptation to make a decision today. And if you could come back as a subcommittee in the early fall and hold, not a public hearing, but a work session to allow some more input, that would still give the full committee plenty of time to hear your recommendation and consider it before the reporting deadline comes up.
Okay. We'll
Thank you.
definitely take that under consideration. Thank you for taking the time to speak. Appreciate it, and to come out. Do you mind just repeating that into the mic, Sam, while she hands those out, just so that those listening know? Absolutely. Thank you. Oh, can you say that one more time?
Yes,
Sorry,
I
'cause the
can.
mic wasn't on.
We have Marissa Chase here, the Executive Director of the New Hampshire Association for Justice. I'm Samantha Hearing. I am a board member of the New Hampshire Association for Justice and an attorney at Douglas, Leonard and Garvey.
So what I just passed around today, and thank you all for taking the time. I know this is Representative DiLorenzo in my second summer in a row getting to talk about all this. I learned a lot today at the Human Rights Commission. This is a complicated issue. And that's kind of always been our struggle as our organization that wanted to pass Senate Bill 296 and then House Bill 362 is for us, it's a really simple little thing. I mean, we have data from the New Hampshire Commission for Human Rights, which is in your packet, in response to a 91A request of October 5th, 2021, that shows when a respondent removal versus post a probable cause finding, which is again the standard of there could potentially be discrimination here, right? It's not supposed to be, adjudication, judge, jury. Let's see, in 2015, there were 13. That's high. We heard today for 2022, there were 22 cases. But on average, 2016, the respondent removed six cases after a probable cause finding to Superior Court. 2017, 1. 2018, 7. 2019, 7. 2023, 2021, 5. This is not a large number of cases that are being removed by respondents to Superior Court, where a claimant then has to start all over again and more likely than not hire an attorney or not pursue their case. But to those people, it matters a great deal. To those people that have to start at the Human Rights Commission, that go through that whole process for years, waiting a decision, and then to have the game start over, that affects them. So while we got into these other issues of peeking under the hood at the Human Rights Commission, why things are taking so long, because of concerns that you all heard in testimony from, both lawyers on both sides of the employment scale. The resource allocation, I'm glad that that is all moving along, and I thank you all for increasing their resources for the Human Rights Commission in the budget, and so glad for Representative McLean's advocacy in the performance audit review. I think that'll be fascinating. I think that will inform, as Representative Katab said, other potential policy decisions. It doesn't really impact 5 cases a year. As we saw today, the Human Rights Commission can absorb about 5 cases a year. It could absorb 22 cases a year. That really doesn't have anything to do with delaying this to see how more investigators are working out or what the performance audit review says. I see them as very separate, and this is something that is a simple fairness issue, not a resource allocation issue.
Thank you.
I would echo essentially everything that Marissa just said. I would also add on a little bit. Those few cases a year that are being removed by respondents to Superior Court after a probable cause finding, it looks like this for employees. They are a waitress or a busboy or a Target employee making minimum wage, and they are sexually harassed. They complain, instead they get fired. So they pursue a charge at the Human Rights Commission. They have very low wages. Maybe they've only lost a total of $750 by the time they find an attorney. When they call me and ask if I can represent them in court, I'm unfortunately going to have to say no, because I am paid on a contingency fee basis, because employees like that cannot afford to pay hourly. I can't afford to work for free because I have to keep the lights on. And so I do a contingency, which means whatever I get for you, I take a percentage of at the end, but I defer all of my compensation until the very end. The compensation is determined by lost wages, which means there's no money for me to be paid for my time at the end. So people like that will not be able to get an attorney. They'll have to navigate a complex court system and litigation on their own, and most people are just not equipped for that. I would just briefly note as well that we've heard from attorneys who oppose the bill on a variety of occasions, and one recurring theme that I keep hearing is, what about the employer's right to a jury trial? There is no right. There is no constitutional right to a jury trial. For the employer, yes. The only constitutional right to a jury trial that exists are those rights that were in existence at the time our state constitution was passed in, I believe, 1794. And 354A didn't come into existence until the 60s. So that's not an issue here. And Representative McLean covered it well, so I won't hover here long, but the choice of forum belongs to the person who bears the burden of proof. That is a principle of law that runs through our state system and federally. And I would also welcome data on whether or not it is correct that New Hampshire and Rhode Island are the only states that allow the respondent to remove.
New England states.
The only New England states, excuse me. It bears noting how respondent removal even got into our statute. My understanding is that when 354A was being passed, we were looking to a constitutional challenge that was ongoing in Massachusetts. And we were nervous about somebody raising a similar constitutional challenge here, and so we put the respondent right of removal into the bill, essentially as a peace offering to get it passed and move on. Massachusetts, it never even made it into their bill. It never, the respondent didn't end up having a right to remove over there, so it ended up being a non-issue. And to the extent that the EEOC may view a respondent's right to remove as retaliatory, I have to say I agree. And that's why I've been here at every session that I've been able to come to and sit in front of you folks. There is no legitimate reason for the respondent to remove to court. None. I can't stress that enough. I can't even come up with a hypothetical reason that would be legitimate. And so with all of that said, I think that's all I have for now. Happy to field any questions.
Does anybody on the committee have any questions for either Ms. Chase or Ms. Hurd?
Attorney Chase, I wanted to ask, it doesn't really matter whether New Hampshire and Rhode Island are the only two New England states, because if the EEOC views removal as retaliation, that's a national policy. So I'm just curious about why you would be curious about what other states allow respondent removal.
Just for the sake of always telling the truth. That's it. I just wanted to clarify the truth for the record. Speaking of which, I am not an attorney, but I work for them, but thank you. No, and again, that was not a fact we brought up. That was what Sarah Burke-Cohen at the Human Rights Commission said. And I just wanted to make sure that nobody was operating under any false assumption. But I totally agree with you. It doesn't matter if we are one of 49 or one of 2, if the EEOC views it as retaliatory, and we would agree.
Thank you.
Does anybody else on the committee have any questions? Okay. Thank you. Appreciate it. So I guess what I'd like to hear is, where's everybody at? I don't personally seeing my position on this changing, but I'm happy to, there's no harm in us coming back in September and just doing another quick session just to vote on it. But I'd like to just, where's everybody's kind of head at with this? How does everybody else feel? Rep. Morgan?
Sure. I mean, that's my feeling. We don't need to make any decision today. I mean, they gave a good accounting of themselves. The institution seems to be functioning more or less as intended, although they are expanding their staff, which will make them get to the cases quicker. And and they do go to great lengths to try to mediation in the early steps of the process. They can also have conciliation, which is forced mediation. And as I said, we did hear about the low number of public hearings, but turned out that's basically kind of the way the process was designed to work. The public hearing is the last resort. So.
Thank you. Rep. Andrews, do you have anything to add?
Thank you, Madam Chair. As far as making a decision today, I don't feel we have to, because the hearing I was in this morning, they were saying we didn't have to do anything until September, October, because it won't come up until November. So we have plenty of time, and I would really like to see what the audit brings us and see if we can get some information another couple of months. It's just how fast the commission is coming forward with these cases, so that see if it makes a difference.
I agree with that. And actually, just reflecting kind of on what you mentioned, I guess I would say that typically the period to enter in a new LSR is September. But if there's a subcommittee, then the subcommittee kind of has until November to make a decision. And so for that reason, if something did come out of the legislative autumn that was, I guess, after September, but before November, then we would kind of have that period where we could potentially put something else in if needed. So if, I guess, if everybody's okay with that, we could, reconvene, in September and kind of see where everybody's at. Is that okay with you, Rep.
Sounds
Dealanza?
great. Thank you.
Yeah, I'm fine with that.
All right. Well, thank you all for coming out. I really appreciate it, and we look forward to meeting again in September. Thank you. I'm going to close the hearing. It is now 1:54. Thank you.